All right, and with that development, we want also to weigh in with our panelists already here to take us through and a raft of other issues that we'll be discussing this morning. We have with us Miguna Miguna, who is a consummate lawyer. Also, we do have with us Senator-elect of Igembe South. This is Mithika Linturi. And also we have the former town clerk of Nairobi. This is Philip Kisia as well. Kimani Matangi is away. They could not make it today. Also, Boni Khalwale and Midua as well. So we continue pace with the conversation, of course, looking deeper on what will be happening on Saturday as well. Right, let's begin with you, Miguna Miguna. Right, new development. Of course, this also has been captured by the People Daily on the front page of the People Daily today, where we have, we have YCJ could miss petition seating. This is what we have there. Focus shift to Justice Maraga, devout Seventh-day Adventist, head of judiciary, who had said he does not work on Saturday, the day presidential petition holds crucial sittings. Right, some of the things maybe that we might gloss over when we're doing the voting, but sometimes it really comes to bear at crucial moment like on Saturday. Miguna.
But I don't think it should have any bearing right now,
yes,
for two reasons. Number one is the Chief Justice and the President of the Supreme Court, and he has a duty to be able to draft rules that govern the function of the court.
Yes.
And one of the rules was to define what a working day is for the court. And he and the court could have easily excluded Saturday and Sunday because they are not regular working days for judicial officers. Mm-hmm. And that would have taken care of it. If he has not done so, it would be assumed that he is ready to work on Saturday.
Yes.
There is no way that a Chief Justice who presides over the court, particularly on the most important judicial function, which is a presidential petition, can skip Saturday. There is no way, in my view, that his colleagues can accommodate him, the answer that he gave when he was being vetted. There is no accommodation because he is, as a judicial officer, as a judge, he has to assess the evidence. He has to listen very keenly to all the submissions. Mm-hmm. And there is nobody who can tell him what party submitted or said in court. Nobody can read for him the volumes of documents that have been submitted. So as far as I'm concerned, the Chief Justice will have to sit on Saturday. He has no option on this one. He took a job, and if he found that the job was such that he could not work on a day which was mandated by law, then he ought to have resigned. He has not resigned, and there is absolutely no accommodation that was included in the application.
All right.
Yes.
Hey, let's hear from Mithika.
I think first, in Debarl, allow me to thank the people of Meru for electing me as their senator, and I'm really humbled by the kind of support I really got from them, and I want to really commit that I will do my best to serve that county of Meru and Kenya as a country. Debarl, what is before us today is something that the interviewing panel of the Chief Justice could have foreseen at the time of interviewing Justice Maraga. And if I remember very well, Justice Maraga was very categorical that because of his faith, he was so clear during the interview, mm-hmm, that it doesn't matter what it is, that in the event there was any case to be handled on a Saturday, then you will not be able to sit on that particular day. So in my view, Justice Maraga brought out his case very early, and the way things are now, we really cannot fault him for saying, you know what, it doesn't matter, I can't sit. He has his right to profess whatever faith he does, and that does not allow him to work on Saturday. I must respect him for that, and I must say that I only find Justice Maraga to have made some bit of administrative mistakes when he was gazetting, when he gazetted Saturday and Sunday, as a day for hearing of the presidential petition. Bearing in mind that he knew very well that he's the chairman of that court, and the law did not allow him to excuse himself from the hearings, then he should not have gazetted Saturday as a day for that hearing. So this leaves us into a state of confusion as a country, because I don't think there are any rules gazetted or any law that allows anyone else to sit on behalf of the Chief Justice, as Miguna has alluded to.
Yeah,
so I
but
think
Miguna says that he knew from the word go that yes, this is of course part of his work. That any case can fall within, that particular sabbatical or the Sabbath day, as it's given right now, and him as a Chief Justice, he should take the higher ground and of course have or sit in this petition.
But this is what I'm trying to explain, that yes, Maraga was very clear from when he applied for this job and said it doesn't matter what it is, I will not sacrifice my faith for anything else. So if his faith tells him you can't work on a Saturday, you can't force him because he had said it earlier. So and I am saying now that's why we are in a state of confusion, and this is a matter that I am not able to comprehend. I'm not able to really come up with an immediate solution, just in case that if the 6 judges sat and made a decision without him, I don't know the kind of legal bearing opposition that it wouldn't have. Because personally, I think, and I also profess some certain faith, we cannot own we can only hold him accountable for really having gazetted Saturday as a working day when he knew very well then he will not be sitting, yet he is the president of the court and the chair of this kind of sittings.
All right, so Philip Kisia, are we facing up a tangled mess as far as this is concerned, faith and or duty, clashing at some point?
Yeah, thank you, Debarl, for hosting me today, and congratulations, my friend Mithika, for this deserving win. I think the issue we're facing is quite a serious issue. The question is whether Justice Maraga can escape a judicial function at this very critical moment. But as Mithika said, when Maraga applied for the job, he said, my faith will not allow me to work on a Saturday. But I think, and I'm not a lawyer, we're only happy to have one lawyer here today. I think the law is very clear that this matter will be heard and determined within 14 days from filing, within 14 days. It never gave room for a public holiday. In my view, it never gave room for any other unforeseen situations. And therefore, I'm persuaded to think that those who are drafting this constitution had foreseen that there could be a gap in this particular area. And if I'm not wrong, I think that the matter at hand is quite serious, is quite weighty, but the law allows that we can have a bench of 5 to hear this matter and determine it. The other thing is, which I'm hoping would happen, is that although, in terms of conscience, would Maraga say that this matter is very weighty and excuse himself from, attending to the other function or duty that he'll be expected to attend in terms of his faith on Saturday, and sacrifice that particular day, and allow him to sit so that he can serve Kenyans, so that this matter can be heard not by a bench of 5, but a bench of 7.
Mm-hmm. All right, so Miguna, you think this will not really have a legal bearing because this is just a petition sitting? Suppose it was a critical day when maybe
it is a critical day, because I believe from reading the papers that that's when the interlocutory applications are being determined, heard and determined. So, for example, a Kuru Court's application to be enjoined, any other party that would like to be enjoined, any preliminary legal issues to be determined, for instance, the alleged late filing by NASA. And So those decisions will be made, and those decisions will have a bearing on the ultimate result. Because if, say, for example, I apply to be enjoined, and I was going to bring a perspective or issues to the table that might affect the result, and I am not allowed to be party to the action or to the petition because of his absence, because he would have probably favored my application and he's the chair,
yes.
Then of course that would have an impact on the ultimate result. I think this is a very important day and function. But to comment on Mr. Kisia's observation about the Constitution, you see, in law, a working day is not defined as every day. We know, for example, that when you say 10 days, for purposes of legal interpretation, 10 days would mean Monday to Friday, then you skip Saturday and Sunday and you go to Monday again. So if you have a court order, for example, and a party is told that you must do this in 10 days, you don't count holidays and you don't count Saturday and Sunday. And I'm saying they could have done that in the rules of the Supreme Court. But as Honorable Linturi has observed, he gazetted Saturday and Sunday.
Yes.
And he ought not to have, knowing very well that he couldn't work on Saturday. Now that he has gazetted Saturday, he must work on Saturday. There's no option. He's paid for Saturday. He's the chair and the president of the Supreme Court. He must work on Saturday.
All right.
Yes.
That's true. Okay, the people also who are seeking to be enjoined, like a Kuro court, we have also AFRICOG and the civil society saying they're not also seeking to be enjoined because, of course, they have a bearing of what happened in 2013 that they were rejected by the courts as well.
I have a problem with that. The fact that I've gone to court and the court has decided a case against me should not prevent me from returning to the court with the same application for a different case. So this is 2017.
Yes.
This is a different petition. It doesn't mean that they will be rejected. First of all, the bench is different. The issues are different. The petitioners, the two of the petitioners may be the same, but the issues are not the same. So I would urge any party like AFRICOG, KHRC, any other organization that wants to be enjoined,
yes,
to go and make the application. In fact, not in every case do you apply because you anticipate that you would win. Sometimes you apply and approach the court knowing very well you're going to lose, but you are aware that the issues must be aired and you need that discussed in the public space. So they should do that.
All right, Mithika Linturi.
And the only reprieve that we may have on Debarl is if the law has not, or any other regulation or any rules by the Chief Justice do not insinuate that for a presidential petition to take place, the TJ has to sit. Because if I remember very well that the quorum of the Supreme Court is a minimum to 5 judges. So if 5 judges are available and are sitting, then I think they can be able to hear any matter that is before the Supreme Court. Because I think we may not just say the case may not proceed or not be end within the period expected, because Justice Maraga may not be able to sit on a Saturday, because unless if Miguna is of a different view or tells us whether there is any mandatory provision that the quorum that is required for purposes of hearing the presidential petition must be 7.
There is. If you are a bench of 7, then you must sit as 7. Here is a bench of 7. So if you don't sit, it means you will not take part in the other subsequent proceedings. So if he wants to have a say on the determination of the issues before the court on this petition, he must sit at every sitting for the entire proceeding.
So from the go-getting, he has to be there.
Nobody can hear evidence for you. Nobody can hear submissions for you. Nobody can evaluate and weigh the case
Agreed,
for you.
but then
Yes.
the laws, then if that's the case, then it means only 5 judges are able to listen to the petition in the absence of the judge, and as long as the judge does not appear in the subsequent proceedings.
No, that's not the law. The law says a minimum is allowed. It
Or
doesn't
5.
say it says a minimum of 5 is allowed.
Yes.
But only when you have a bench of 5, which means that if you have a bench of 5, yes, they can proceed. Here you have a bench of 7. A bench of 7 must sit in this case.
So a bench of 7 from the go-getting, not 5 because we have 2 who are missing.
No.
So we begin with
It
the
should be
5
7.
all the way. It should be 7. So
Yes.
if it is 7, it is 7 from
It
the
is 7.
go-getting. Or let's hear from Philip Kisia.
I think, well, I will not claim that I have any authority to disclaim what my friend Miguna said. But if that is the law, then it's a very unfortunate law. Because supposing something else happens that is unforeseen within the 14 days, touch wood, somebody falls sick and is admitted at ICU, does it mean that the matter does not proceed? So if that is the law, then it is very unfortunate. But I still believe that the law allows 5, and in between, if somebody drops and they find that they are 6, then probably 5 should sit, because you cannot have a situation where you have an even number, and when you have to make a determination, you have equal numbers.
No,
even numbers.
actually, you may have misunderstood me. What I mean is this, that if there are less than 7, so say for example 5, because 6 cannot sit, right?
Yeah.
So it means he will not partake, he will not take part, he will not participate in the rest of the proceedings. Because if he wants to have a say in the final determination, then he must sit. As I said, because nobody can substitute a decision or view or inject something for him to use. So what I'm saying is that if he's not there, say for example, on Saturday, when an important issue is before the court, my view, and they can disagree with that view, I'm not saying my view will, of course, guide the court. My view is that he should not participate for the rest of the proceedings. But I'm not saying he will, they can overrule that and say, you know, he will hear from his brothers and sisters.
Yeah,
Okay.
I found the solution in the Supreme Law. The Constitution and Article 163 establishes the superior courts, and this and particularly 163(2) says that the Supreme Court shall be properly constituted for the purposes of its proceedings. It is composed of 5 judges. So this means that as long as 5 judges are seated, then they can hear any matter before it. And in this case, if Justice Maraga is not able to sit on a Saturday, and if what actually Miguna is saying is the truth, then from the beginning of the hearing of this petition, because Maraga knows that he won't be required to sit on a Saturday and he will not be available, then they can agree to have a minimum of the 5 or the 6 judges, but then
For the entire year.
for the entire period,
Yes.
meaning that the case will be determined in his absence, not really withstanding.
But you
from the
see,
hearings.
that will not work in this case.
Yes.
Because everybody knows that different judges have different philosophies, different ideologies, different jurisprudential leanings.
Yes.
So say, for example, you decide Justice Maraga is not going to sit. And then, because you have to be 5 or 7, you decide that, for example, Justice Njoki Ndung'u is not going to sit. You can see a problem right there. Because maybe there are parties that would want Justice Njoki Ndung'u to sit. There are parties who are particular about Justice Maraga. That is why it is very important, because then it would look like you are artificially structuring the court in a way that will lean on one side or the other. That is the perception that should never be there. So for that purpose, because at the end of the day, what is the court supposed to do? The court is supposed to render justice. That is the most important thing. In fact, you have to vacate your other idiosyncratic or even faith and other leanings or beliefs for the purposes of justice. So on this case, I would urge Justice Maraga to forfeit his faith for purposes of rendering justice for Kenyans. Kenyans and their faiths and beliefs and collective wishes and desires are more important than the faith of one person.
And of course, not to forfeit his faith entirely, just for the purposes of
only
this.
for that day.
For that day,
and only for this petition.
You know, people might think you're telling him, well, forfeit your
Then
faith.
we must agree that that's a decision for Maraga for the sake of this country.
For the sake of this country.
And then we really cannot really go forth or condemn him for that. But I think it suffices to say that why the Supreme Court has 7 judges is because it is expected at no single time that the judges may all agree
Or an evil kill, yes.
or give a ruling that will be agreed by all of them. So, and for purposes where we will be required to go by a majority vote, then we would have at least 5 to 2, 3 to 4 of that kind of judges that may be giving their opinion on any case like that. So even with the 5 judges still, then there is no single time we would expect the 5 to tie. So I think we have an issue, and I think the person that can be able to sort out from the kind of quagmire that we may find ourselves in is Justice Maraga, and I only pray that solomonic wisdom prevails upon him really to let this country,
So you're praying,
the anxiety that is trying to build up in this country, come to an end.
He can pray,
You're praying he doesn't go to church on Saturday.
At the courthouse. God is everywhere.
All right, let's hear from Philip Kisia. We have also an issue with, which is really coming to the fore. This is bearing also with what was in 2013. Issue of faith is coming to the fore. The 14-day window period is still also coming to the fore, where we found that the opposition by then was really strapped for time, and they brought, tomes and tomes of evidence at the last minute. But of course, because of time, that could not have been accommodated. But still, we are faced with the same 14-day window period here, and this was not really addressed even with the members of parliament. You actually glossed over this issue because it was brought to the fore of the House, and you never addressed it. Now we have it here again. How is that also trying?
Kisia was not a member of parliament.
Not Kisia, I'm talking about...
We increased.
Well, I agree.
Was increased.
I agree with
Was it increased? Let's hear from Philip Kisia.
I agree with
For 7
Miguna.
days then.
I am not a member of parliament and I've not been one. But I think, in my view, the 14 days window period to deal with a very, very heavy matter like this one, in my view, is inadequate. And probably, I don't know that this one requires a constitutional amendment or just an act of parliament to amend from 14 to maybe 21, maybe 30 days, to give all parties adequate time to prepare for this particular issue. So probably the 12th parliament should consider this matter very seriously and look at it and find ways of increasing the number of days that are required to dispense off with this particular matter.
Yes.
14 days, in my view, are very few days.
Right, 14 days.
I agree with Kisia that 14 days is not just inadequate, it's unconscionably limiting. There is nothing significant anyone can do on such an important petition in 14 days. If you have had parties talk about the evidence that they have submitted, I've not seen all of it, but they have been talking about from 9,000 to 25,000 page documents. So there is nobody who can read that amount of document in 14 days. Even if they stayed awake for 14 days without sleeping and they are completely alert. They will not be able to read it in 3 months and digest it and be able to make a decision that is considered fair and considered. So in the United States, if you remember, and this is the pure presidential system that our drafters, the drafters of the Constitution, tried to map our constitutional framework on. The elections happen in November, and the president assumes office in January. So between November and January, that's more than 2 months to be able to sort out all these issues of transition, whatnot, petitions. And that would be an adequate time for this to be done. But 14 days is completely inadequate, and I think members of parliament can change that article in the constitution to be able to allow more time. I also find the filing is unnecessarily voluminous, unless, of course, it is just the Form 34 A's and B's. I have had people say, and it is true, the evidence is not based on volume, it's based on the quality of the evidence and the quality of the submissions that are made. So if it is just voluminous and people are not going to read it, then of course it makes no sense. Then of course the late filing by NASA. I think that is unfortunate. They had an issue about late filing in 2013, and they had 800-page affidavit that was not allowed, which they believed contained crucial evidence.
But this is
now they do it again, and then they explain it by saying these documents are not material. If they are not material, why are you filing them?
But we have their judge or their lawyer, that is Paul Mwangi, stoutly denying
Paul
that
Mwangi's explanation means nothing. In fact, it is ridiculous. He's saying that the time of paying the fee, apparently in Kenya, you know, the registrar assesses how much you should pay for any specific action or petition. And so they paid the amount and the security for cost. They are saying that because the receipt was written the August 18th, it should be deemed that that is when they filed. But that's nonsense. They filed on Sunday. They didn't file on the 18th. So why are you saying that the receipt implies that you file on when you didn't file, and you know when you filed, and you know you filed out of time? What they should have done, and I don't like these arguments from Kenyan lawyers.
Yes.
They should have made an application for an extension of time and asked the courts to allow them the extra 1 or 2 days to bring in more information. And if it was inadvertent failure to file, for example, because they had a lot of documents, they failed to present that, but they had it, and they should have presented it, but because there were so many documents, they forgot.
Yes.
That's okay also. But don't come and tell us reasons that make no sense.
All right, thank you.